It says win. Unite secures landmark legal victory in Coastal Christmas bonus case. And I've read the case pretty much. I'm not an expert on law, but I have to say, what happened in this case, the Coastal case, you were integral to this case because your name's all over the documents from the case. Can you tell us the story of what happened with this pay offer and what Unite and the whole background to Unite organising in that particular workplace?
Yeah, of course I can. So, good morning all. So in 2014, Unite, the union, had numerous calls from workers, employees of the company called Costal UK, which is part of the automotive industry, which makes parts for manufacturing of motor vehicles. And therefore, they made approach to Unite the union in wanting recognition for workers through Unite the union for collective bargaining rights, such as pay, terms and conditions, holidays, etc., etc. In 2015, after a long organising campaign, Unite secured the significant membership needed to move forward through voluntary recognition with Costal UK. And Costal, based in Goldthorpe, has a clear history of mining communities in the South Yorkshire coalfields, which were decimated in the 80s, hence retail parks and commercial parks where Costal popped up in the 1990s. Therefore, Unite had collective bargaining rights and pay negotiations. The agreement was signed in February 2015 with the business, and pay negotiations started, the first ones under this agreement, in October 2015. The company made an offer to the union and the members were balloted on the offer. The offer was rejected by the members, and the company then made the offer to individuals and stated that if they did not accept the offer, they would not be paid their £270 Christmas bonus, and they would not be paid it at any format if they didn't sign it. So 60 brave employees did not sign for their Christmas bonus, and in turn did not get the pay rise associated with that at that point in time. I made it crystal clear as the full-time officer for Unite of Costal UK that the company were bypassing collective bargaining, and I put the company on legal notice on behalf of our members that they were in breach of the 1992 Labour Relations Act under section 145B of that point, which is classed as inducements. And some people have talked about them as being bribes, but the legal term is inducements in regards to that point. And the law clearly states that inducements should not be made in order to take collective bargaining away from a group of workers. The company argued the fact that they were wanting to collective bargaining next year, so therefore were not in breach of this law because it was not permanent in that factor. We put the company on legal notice. We then won the initial tribunal in Sheffield Tribunal, and the workers were initially made the compensation payments for 2 inducements, which in total resulted in £7,600 per member for the 60 members, which in turn were £420,000 in fines for the business. However, after a long 6-year legal battle, the Court of Appeal overturned it in favour of Costal, and then last Wednesday the Supreme Court clearly ruled in favour of Unite, and therefore it is now illegal for companies to make individual offers and bypass and take away collective bargaining on that point of view which was stated. This is not just significant for 60 individuals who now receive £581,000 in compensation because of the interest which is gathered through that point, which in turn results in £10,000 for each member, which in theory, in very low paid wages in an area such as Goldthorpe, is significant for the local community, but also is significant for the trade union movement as a whole, which now states that employers have to clearly take notice of the collective bargaining recognition agreements that are in place and cannot bypass it or offer inducements to individuals so that collective bargaining mandates are ripped up and destroyed during that round of negotiations. So really significant for every trade union collective bargaining agreement. But I do want to make one point, if I may. This does not substitute in any shape or form the power of collective trade unionisms. And what I mean by that is a group of workers who stand together and have clear density and join a trade union clearly has increased terms of conditions moving forward. And there's no doubt that the demise in wealth and distribution is clearly linked to the demise in collective bargaining. And this was a clear attack to put more pressure on the collective bargaining and destroy it. And the Supreme Court have made a significant judgment in protecting collective bargaining, but also significant that it is so important to be a part of a trade union when in the world of work and also in communities. Thank you.
That's fantastic, Simon. I was really impressed by what you did there, because I can imagine that company really thinking they'd pull the fast one there, and with that Christmas bonus, it's like something out of Dickens.
Yeah, it was, and there's no doubts that press releases at the time had clear Scrooge points to it at the point in time. The thing is, though, this was nothing new at that point in time. Companies tried to undermine trade unions and the collective on numerous occasions through a point that if they feel the union does not represent its members, or in what case they try and bypass that and get that point of view. It was because we had 60 members in that workplace who were committed to getting collective bargaining for their workforce and future workforces moving forward. But let me make this clear. It's so important that collective bargaining remains substantial in the world of work. In the 1980s, ACAS clearly stated that collective bargaining was the proposed way for industrial relations. In 2021, that is no longer the case. The government does not support collective bargaining as the formal way of trade union relations. And we must push as a labour and trade union movement that collective bargaining is the only way to have clear, solid industrial relations with workforce and companies moving forward.